Tom.
Thanks, Mr. Chairman. Thank you all for being here today and answering our questions. I don't want to talk about new laws. I want to talk about a very old one, the Constitution of the United States, specifically the Fourth Amendment. This picture is of ICE agents forcing their way into the Minneapolis home of Garrison Gibson, banging down the door, detaining Mr. Gibson in front of his wife, Tiana, and their 10-year-old daughter and niece who happened to be there at the time. I don't know whether you're familiar with what happened here. It's one of many, many, many similar incidents that have happened all around the country. And it was done pursuant to what is called an administrative warrant. I'm going to hold up a copy of that warrant, signed by an SDDO, who is, I believe, a member of the ICE workforce, another agent, a supervisory detention and deportation officer, not a judge, correct?
Correct, Senator.
So, in effect, this is not a warrant, it's a permission slip. It's a green light from another ICE agent to go bash down a door, smash into a home, detain and arrest someone without a judge finding probable cause and without any sort of objective, independent finding. Is that correct?
No, sir. So the I-205 is the arrest warrant, but the I-205 is based on an executable final order issued by an immigration judge from the Department of Justice.
And that order is from an immigration judge who is part of the executive branch, not an independent judge. But the warrant issued is simply a permission slip. Now, let's be very clear. You were a local police officer.
Yes, sir.
To bang down a door, barge into someone's home, if you're the FBI or a local police officer, you need a judicial warrant from a judicial officer, a judge, who is going to find or not probable cause, which has a specific meaning under the law. These ICE agents are banging down doors, doing the same thing without that kind of judicial warrant. What is so different about ICE that it regards itself as an exception to the Fourth Amendment? And the requirement for a judicial warrant is a Fourth Amendment requirement.
We don't, Senator. There is case law, U.S. versus Lucas, 2007, which is out of the 8th District of Minnesota, which authorizes the entry of a home to catch a fugitive based on an administrative warrant.
I beg your pardon, sir. It does not abrogate the Fourth Amendment. It does not say that ICE agents or CPP agents can simply bash down doors and barge into people's homes, terrorize their children, detain and arrest people without a judicial warrant. And there is nothing different about what ICE does as compared to the FBI or local police that would justify it. The policy that they're acting under, in fact, is the result of a memo that you issued in May. You're familiar with it.
Yes, sir.
Has your signature.
Yes, sir.
Which says, in effect, they don't need judicial warrants. They can act on the basis of the 205 warrant that you've just described, which is administrative. It's not judicial.
So let's talk more about it.
Why did you keep this memo secret?
I didn't keep that memo secret, sir. It was blasted
Well,
out.
we learned about it when 2 whistleblowers came to us and said that you were using it as a basis for the policy. It was never announced publicly. It was never released to the press or the American people. Why did you keep it secret?
Sir, I didn't keep it secret. If sending an email to a workforce of 30,000 people is keeping something secret, it's a bad secret.
It never reached those people.
Yes, sir, it did.
Well,
The email did, sir. Yes, sir. I can work with your committee to get,
let
and your
me,
staff to get that.
let me move to another topic. You stated on Tuesday, quote, "No U.S. citizen is subject to immigration enforcement, and that doesn't happen. If a U.S. citizen is detained in the course of the immigration investigation, they are quickly released." I ask unanimous consent that a report that we did, the ranking member staff did, entitled Unchecked Authority. It documents 22 U.S. citizens being detained and assaulted by immigration agents, as well as written statements from 8 U.S. citizens who have been detained, shot at, and nearly killed by ICE agents who came to speak.
Without objection.
Thank you. So let's take George Reitz, for example. He's an Army veteran, a father from California, trying to go to work. He said he was tear gassed and held for 3 days without charges. Is he lying?
Sir, ICE wasn't involved in that arrest, sir.
Were you mistaken when you said that no U.S. citizen is subject to immigration enforcement?
No, sir.
Well, who's lying, you or him?
Sir, I'm speaking for the men and women of ICE in my operation. I didn't arrest that individual, sir.
But the facts contradict what you said. Will you admit that you don't know, for example, about Alaya Rahman, a disabled woman from Minneapolis? She came to this hearing. She testified before our Spotlight forum, violently dragged from her car, detained without medical attention until she passed out. Is she lying, or are you lying?
No, sir, she's not lying.
Well, then you were mistaken when you said no U.S. citizen has been detained.
No, sir, I said no U.S. citizens subject to immigration law and deportation or removal. ICE does
Well, that's
detain.
a circular argument. She
I don't-
wasn't subject to immigration law because she's a U.S. citizen, but she was detained, and that contradicts directly, as does your statement applied to Miramar Martinez, who was almost killed, shot 7 times by CPP agents. It is true of Diana Figueroa, who told us she was violently dragged from her car after dropping her son at school, thrown into a van, also detained. Is she lying?
No, sir. But, sir, you know, I've worked personally with you on many cases when you come to me on constituents, especially in Connecticut when I was a field office director in New England. You know that I am transparent and we do not lie. So to say that we're lying is
I
incorrect,
asked you
sir.
first whether you were mistaken when you said that no U.S. citizen, I'm quoting, is subject to immigration enforcement.
Correct, sir.
Enforcement.
Enforcement
I
is
would
an
call
arrest,
that-
removal.
I would call that misconduct enforcement by your agents. I'm out of time. Thank you, Mr.
Let's go and stop there. I have 2 quick questions. One of the things that came up earlier was this idea that there used to be an instantaneous portal between, I guess, ICE and the prisons where you were arresting, that initially you were just getting this information seamlessly, very quickly, not manually. It was an automatic portal, but that was stopped under Mayorkas. Mr. Lyons, is that true, or
Yes, sir, it's true.
have y'all tried to restart it?
We have restarted it with multiple agencies, sir. And, sir,
go ahead.
just for the record, sir, I will say, again, to the Commissioner for the Department of Corrections, we do have a great relationship with them. We do take individuals from them. You know, there was a report released where we didn't take action on, I think he said 100, I think the number is a little bit more. But the fact that ICE didn't take action on a foreign-born citizen means the fact that they're not removable. There are many people in custody that have a green card, lawful resident, visa. So to say that was disingenuous.
Yeah, the other question I have is that, you know, we finally had the Attorney General say, oh, of course, if it's a final order. He was making a distinction, and I think it's not an unreasonable distinction. There's a difference between a final order and a detainer, legally and procedurally. But he said, oh, sure, we'll cooperate with ICE if we have a final order. And it sounds like most of the targets have final orders. I think Senator Langford indicated that. We'd like to know what the number is. But if 80% of them are final orders and you have 16,000 people that we'd like to remove from Minnesota, I would suggest that you publicly take him up on what he said. he said, oh, sure, we'll do it if there's a final order, because I think that you actually will win some of those arguments, and it's a better way to win those arguments than I think some of the ways we've tried.
Yes, sir. If to that, what I would say is, state of Minnesota at Department of Corrections level, sure, they give us the final order, but it's when individuals are encountered for, at the local level or the county level in Minnesota. That was the issue that we were having. So they might stop somebody, identify them, they have a final order, have a criminal history, they re-release them back without notification to us.
Yeah, I'm talking about when you have a target and they're not corresponding to you. So you send them an email, I've got this target, will you send 10 Minneapolis police? Is that ever happening? Are you ever having Minneapolis police go to help you make an arrest?
We would never have them make the arrest or go with us for us. We would use them for like site security, perimeter security. In almost every jurisdiction in the states, we do that. But then if they say, they can't go because it's immigration enforcement, so be it.
I know he's made a lot of orders in the opposite direction. I'm just saying I would test him in the direction of the things he admitted that he says he would do. I think pushing forward with that is a good idea. The other thing that came to my mind is if you don't have a final order, and he's making the distinction, well, detainer's not really an order, and we're not going to, you said there are other states that do this, we're not going to keep you beyond your 3 years in prison, even one day on a detainer because it's not really an order. If somebody's in prison for 3 years, why don't we do why don't they go through immigration court while they're there and get final orders? Who's in charge of that? Is there, if we notify you on day one, is it you or is it some other agency? On day one, someone's here, he's here in the country illegally, he's going to be in for 3 years. That's certainly a lot of time. Certainly, we ought to be able to prosecute him while he's in prison.
We do, sir. Many states, we do that. It's the Institutional Removal Program, IRP. Massachusetts, New Hampshire, we do that. While they're in custody, we go ahead and put them through immigration proceedings. So that way, there's no cost to American taxpayers as well. The day they're released, their travel is already arranged, and they go straight to the plane.
I would say it avoids that controversy then, and the more of that you can do, the better to get to the final stage, so you don't have to encounter the argument on a detainer. Senator Gallego.
They said this could never happen in America. But what if I told you federal agents can now kick down your door without a real warrant? That's exactly what exploded in a heated Senate hearing this year. One senator took ICE head-on, throwing the Fourth Amendment right in their faces, and what he exposed will leave you stunned. Here's what actually went down. Picture this: a family in Minneapolis sitting at home when ICE agents smash in, terrifying a mother and her kids, all because of a permission slip, not issued by a judge, but signed by another ICE agent. Let that sink in. If the FBI or your local police want in, they need a judge's signature and probable cause. But ICE? They're using internal documents, not judicial warrants. That's where things got heated. The senator demanded, what makes ICE so special that it doesn't have to follow the Fourth Amendment? And for a moment, the room went silent. ICE tried defending their actions, pointing to some legal precedent. But the senator shot back, reminding them that nothing, absolutely nothing, gives ICE the right to invade homes without a judge's say-so. But it got even worse. The hearing turned to reports of U.S. citizens being detained, or worse. ICE claimed, no U.S. citizen is subject to immigration enforcement. Sounds safe, right? But the senator had receipts. Veterans held for days, a disabled woman dragged from her car, another person shot multiple times. So, who's lying? ICE tried to change the definition of enforcement, but the senator called it out. Detention, use of force, that's enforcement, plain and simple. And here's the bigger issue. This isn't just about immigration. It's about whether any federal agency can play by its own rules, outside the Constitution. If ICE can bypass judicial warrants, what's stopping others? At the end of the day, if this loophole stands, the Fourth Amendment might not mean what you think it does. So, what do you think? Should ICE be allowed to enter homes without a judge's warrant? Or is this a dangerous line that should never be crossed? Drop your thoughts below. I want to hear what you think.